not attempt to defend the substance of its policies and practices. As the Court will have observed, its five-page submission does not, no doubt because it cannot, say anything whatsoever about the substantive allegations made against it. Instead, it focuses almost entirely on why the request of the advisory opinion and the questions contained therein are somehow improper. The only logical conclusion that can be drawn from all of this is that Israel's policies and practices in the occupied Palestinian territory are legally indefensible. This brings me to the next part of my statement. The Kingdom of Saudi Arabia submits that the Court has jurisdiction to issue the opinion, and there are no compelling reasons for it not to do so. To the contrary, given the recent increase in bloodshed and destruction by Israel in the occupied Palestinian territory, as well as the dangerous statements made at the highest levels of the Israeli government, we respectively submit that the Court is under a duty to issue its opinion. I will now discuss the arguments advanced by some states that the Court should not issue the opinion for two primary reasons. First, because the opinion might prejudice a negotiation process aimed at resolving the Israeli-Palestinian conflict, which those states consider to be ongoing. And second, because the questions posed concern a bilateral dispute between Israel and Palestine. Not only are these arguments misguided, but they have been repeatedly rejected by this esteemed Court under highly analogous circumstances, including in the World Advisory Opinion. The Kingdom regards the first argument as being based on a blatantly false premise and devoid of any legal foundation. Its lack of legal credibility has been addressed by the League of Arab States in its October 2023 comments. In the interest of time, I would respectively direct that Court's attention to those comments, which we fully endorse. Simply put, the Court's prior practice should prevail in this instance. The practice gives deference to the General Assembly when requesting guidance from the Court on an issue the Assembly considers irrelevant to its work. As the following demonstrates, the assumption that a serious negotiation process exists is a fiction that offends reality. In the 2004 world proceedings, the Kingdom of Saudi Arabia described Israel's modus operandi in the occupied Palestinian territory since 1967 as, quote, deliberately enhancing its position and changing the territorial status quo to its benefits. End of quote. The Court rightly recognized this reality in its advisory opinion, referring to the illegality of Israeli settlement practice in the occupied Palestinian territory. The Court also warned, quote, the construction of the wall and its associated regime create a fait accompli on the ground that could become permanent, in which case it would be tantamount to de facto annexation. End of the quote. This assessment was precedent and tragically but predictably resulted in no change in Israel's illegal conduct. Now here is this seen more clearly than in the number of legal settlers residing in the occupied Palestinian territory, which has grown from roughly 424,000 in 2004 to some 700,000 settlers today. Since 1967, far from engaging in negotiations, Israel has made it virtually impossible to establish a cohesive Palestinian state. It has done so by annexing more than 2 million dunams of land, building more than 279 illegal settlements throughout the West Bank, illegally annexing East Jerusalem and declaring Jerusalem as its undivided capital, confiscating natural resources, demolishing Palestinian homes, and much more. Those actions are well documented in the many UN reports discussed in the Kingdom's written statement, and I will not dwell on them further, except to make the self-evident point that the Israelis' actions have clearly aimed at frustrating a negotiated settlement rather than the opening the door to such settlement. These policies and practices should be enough to dismantle the illusion that Israel has any intention of engaging in serious efforts towards a negotiated peace. But Israel has also, for good measure, approached actual negotiations with nothing less than impunity and contempt. Mr. President, members of the court, we see this not as spectators, but as a direct participant in efforts towards negotiating a lasting peace spanning decades. That was the case when more than 20 years ago, the Kingdom of Saudi Arabia proposed the Arab Peace Initiatives, which was adopted by the Arab League in 2002 and re-endorsed at the 2007 and 2017 Arab League summits. However, this peace initiative was rejected outright by Israel, with its then Prime Minister describing it as a non-starter, because it required Israel to forgo occupied territories in exchange for peace, a policy that has persisted until today. The reality today has become more discouraging. At the senior levels of the Israeli government, calls are openly made to forcibly transfer or ethnically cleanse Palestinians out of their homeland, expand settlements even further, annex further areas of the West Bank, and at all costs to reject the notion of establishing a Palestinian state along the lines of the two-state solutions. And while the brutal and genocidal onslaught of Gaza by the Israeli military since October 2023 has led it to become, in the words of the United Nations Under-Secretary General for Humanitarian Affairs, a place of death and despair. It should not be forgotten that Israel's aggression has been accompanied by unyielding statements by its leaders that it will never agree to a sovereign Palestinian state or cede control over the occupied Palestinian territory. Such a statement hardly reflects Israel's intention to engage in a genuine peace negotiations. Concluding at this point, I would add that if a serious negotiations aimed at achieving a just resolution of the Israeli-Palestinian dispute in accordance with the international law were to become reality, the Court's opinion could not in any case possibly prejudice those discussions, but rather would enlighten them. Mr. President, member of the Court, the second argument raised by certain states is that the Court should refrain from rendering the requested opinion because it relates to a strictly bilateral matter between Israel and Palestine. This argument has been rejected by the courts in several prior contexts, including the Wall Advisory Opinion, and should, we believe, be disposed of by the Court in the same manner in this case. Not only is the argument legally unfounded, but the fact that the questions posed to the Court are of a multilateral nature is self-evident. As explained in the Kingdom's written statement, the legal questions are located in a broader context, involve erga omnes applications and jus cogens norms, and ask about the consequences of Israel's policies and practices in all states as well as the United Nations. To conclude on the question of the Court jurisdiction, I have with one thought that the Kingdom also voiced in the context of the World Advisory Opinion. If this court, the principal judicial organ of the United Nations, should not consider the critical questions put before it, then we cannot but conclude that the system to maintain international peace and security set up following the atrocities of the Second World War has not stood the test of time. Mr. President, members of the court, I will now address the first questions before the court, which concerns the legal consequences arising from Israel's prolonged occupation and illegal policies and practices in the occupied Palestinian territory. To answer these questions, the court has a plethora of evidence available. This includes the evidence furnished by the United Nations, its organs, UN human rights mandate holders, and the specialized agencies, the special rapporteurs, and the independent commission, all available in the dossier before this court or referred to in the Kingdom's written statement. We submit that the catastrophic consequences of Israel's policies and practices on the ground, as well as their sheer illegality, are undeniable. The international community has seen stark evidence of these consequences during the current war in Gaza. The ongoing situation is so appalling that last December, the UN General Assembly overwhelmingly passed a resolution demanding an immediate humanitarian ceasefire in Gaza, while the court has recognized the possibility that Israel's conduct amounts to a genocide and ordered it to comply with a series of professional measures. However, as we speak, Israel continues to defy the international community's call for a ceasefire and to willfully ignore the professional measures ordered by the court. More generally, Israel has, over the decades of its occupation, resisted egregious violations of its most fundamental international obligations, as explained in our written statement. Israel in continuous breach of several just cause norms, notwithstanding multiple Security Council and General Assembly resolutions condemning its conduct and this court's finding in the World Advisory Opinion. These violations include Israel taking continuous measures to prevent the Palestinian people from exercising their right of self-defense through various policies and practices, including, among others, the illegal settlement practice in the occupied Palestinian territory, the expulsion of Palestinians from their homes, and theft of Palestinians' property, the denial of sovereignty over their natural resources, and the breach of their civil, political, economic, social, and cultural rights. Moreover, Israel has continued implementing its infamous settlement practice in the occupied Palestinian territory, despite the repeated condemnation of this practice by the Security Council and this court's determination of their illegality in the World Advisory Opinion. Yet, Israel makes no secret of its intention to maintain and expand settlements, as well as its possession of all or part of the occupied Palestinian territory, in violation of the Fourth Geneva Convention and the prohibition and the acquisition of territory by the use of force. Israel's 2018 Basic Law also shows Israel's disdain for the Palestinian people's right to self-determination by declaring the holy city of Jerusalem complete and united as Israel's capital, stipulating that, quote, the exercise of the right to national self-determination in the state of Israel is unique to the Jewish people, end of the quote. It's also incompatible with the Palestinian people's right to self-determination in the occupied Palestinian territory, including East Jerusalem. The international community has spoken on these issues on many occasions through the United Nations principal bodies, demanding that Israel completely ceases all settlement activities, revoke its annexation of East Jerusalem, and comply with its international obligations in other respects. The list of resolutions is long. We have addressed many of them in our written statements. Israel continues to ignore them. But Israel's breaches of international law don't end there. There can be no serious debate that Israel's policies and practices also amount to the racial discrimination and are tantamount to apartheid in the grave violations of the Palestinian people's human rights. Israel's seizure of land and resources for Israeli settlers and discriminatory application of laws, regulations to the detriment of the Palestinian people are merely examples of this egregious conduct. Israel violates the human rights of the Palestinian people in multiple other ways and in breach of its conventional obligations, including the rights of women and children. Mr. President, members of the Court, the Kingdom of Saudi Arabia wishes to emphasize that the international law obligations, particularly those embodied in the preemptory norms of general international law, are not abstract rules and are not intended to be. Their violations entail particular legal consequences, but also has real and tangible consequences. The latter include, most prominently, the denial to human beings of the right to life and dignity, and more widely, the creation of threats to peace and stability, with unpredictable consequences. The multiple and grave violations by Israel of its international obligations in the occupied Palestinian territory is therefore of undeniable concern, not only to those directly affected, but also to the international community as a whole. I will now move on the second question before the Court regarding the manner by which Israel's conduct affects the legal status of its occupation. The Kingdom respectively submits that the only conclusion which may be reached from the multiple and grave breaches of international law emanating from its occupation is that Israel's occupation itself is illegal and must be brought to an unconditional end. Any other conclusion would be anomalous and inconsistent with the clearly illegal origin and conduct of the occupation, including the violations of just cause norms that Israel has and continues to engage in through its occupation. To be clear, Israel's occupation was, from its commencement in 1967, an illegal use of force and continues to be so. The Kingdom noted this in its submission in the Wall Advisory Opinion. The illegal nature of the 56-year occupation has only been aggravated by Israel's numerous other international violations, including just cause norms. Given the illegality surrounding every aspect of Israel's occupation, that occupation is simply indefensible as a matter of international law. For those reasons, we respectively ask the Court to expressly declare that Israel's occupation of the Palestinian territory is illegal. The Court is also asked to address the legal consequences of Israel's breaches. I will address these briefly. The Kingdom of Saudi Arabia and numerous other states have laid out in the written statement the legal obligations which flow from Israel's breaches. Pursuant to Article 30 of the Articles on State Responsibility, and as explained by this Court in the Wall Advisory Opinion, Israel must cease its wrongful conduct, resume compliance with its obligations, and offer appropriate assurances and guarantees of non-repetition. Article 31 and 36 also require that Israel makes full reparation for the damage caused over the decades of its illegal occupation. As for all other states, Israel breaches of just cause norms entails that the international community has an obligation not to recognize that illegal conduct. All states must also cooperate to bring Israel's violation of international law to an end and make sure that they don't render aid or assistance in furtherance of Israel's breaches. The consequences for the United Nations are clear. All UN organs must, within their competences, take steps to bring Israel's violations to an end and they must also refrain from recognizing these violations or giving aid or assistance to maintain the illegal situation. Finally, they must also require the unconditional and immediate end to the occupation itself. Mr. President, members of the Court, thank you for your attention. This concludes the statement of the Kingdom of Saudi Arabia.
Its presentation, I invite, before I invite the next delegation to make its oral statement, the Court will observe a coffee break for 10 minutes. The sitting is suspended.